Hi, welcome. I'm Mike Cruz, CEO of North Texas Wealth Management. We have a webinar series that we've began. We're going to talk about legal stuff today, estate planning. We have a special guest, Mark OBriant, here with us, an estate planning attorney. And then, stay tuned for our upcoming other events. We're going to talk about Social Security, Medicare, Medicaid planning, everything from tax and property insurance. So look for those upcoming episodes. But today, Mark OBriant, thanks for being here. Mark, I think I've known you for about 20 years now.
Right.
You've helped a lot of our clients. Even, a long time ago, I tried to get my estate planning done online, and I had Mark review it, and there were a lot of corrections. So, thanks for being such a resource to our clients. Glad to have you out. But if you would kind of give the people that are, tuning in today, give them kind of a background. Like, where'd you go to school? How'd you get started?
All right. Well, I'm a Dallasite. I was born and raised in Dallas. For a long time lived over close to Love Field. And then later my dad got transferred. We moved to Garland. I wound up graduating from Garland High School. And from there I went to college at North Texas State University. And I was a math major. And my last semester, when I was getting close to graduating, I started wondering what I could do with a math degree. And I figured, well, I can always teach. So I wound up teaching school, teaching math for a year. And then during that time, I decided to go to law school. I went to law school at the University of Texas, started down there in 1975, and I got my law degree in 1978. I was licensed that year, so I've been practicing attorney for 45 years.
Wow. That's great.
And over those years, I originally did a wide variety of legal matters, and then decided to really do most of my practice in wills, trust, probate, and real estate. And so that's for many, many years. Those 4 years have been my area of concentration.
No, that's great. So when you think about, a lot of clients will sit down, and sometimes I don't even think they know where to begin. So where should you begin? What's the conversation about? I know I need to get some legal documents in place, or do I? So where should they begin?
Yes, well, one of the fallacies that I hear people say is, why do I even need a will? I mean, in Texas, everything goes to the wife. And I hear that quite commonly. And that actually is true sometimes, but oftentimes it is not true. Texas is a community property state, so it is true that the spouse, of course, owns half of the community property. But Texas does recognize separate property, and if you do not do a will, then generally the spouse at most would only receive 1/3 of the separate property. They may or may not receive the other half of the community property. So it is not true that the spouse always gets everything or even always gets the community property. For example, if a person has stepchildren in Texas, if there are stepchildren in the family, then the wife does not receive everything from her spouse that dies. She keeps her half of the community property, but the husband's half of the community property will pass to his children. So if he has children from a prior marriage, then his half will go to those children. If he has children from 2 marriages, then the property would be split among the children, the total children that are his. And then if they're separate property, the simplest explanation is that typically the wife would get 1/3 of the separate property and the children would split the other 2/3. So it's important to have a will because it is not true that everything's going to go to the surviving spouse. And another misconception people have is that stepchildren inherit. If a child is your stepchild, they will not inherit. Sometimes people believe that if they have a married child and that child dies, then everything would go to the in-law, to the son-in-law or daughter-in-law. That's not true. In Texas, in-laws never inherit. And so if you want to change all that, you need to have a will. Because if you do a will, you can determine who gets your property and in what percentages.
Mm-hmm. So you mentioned separate property. What is separate property? What counts as separate property?
Okay. Well, approach it from the other way, because in Texas, you start off with a presumption that everything is community property. Community property is property acquired during the marriage, but there are exceptions to that. So the things that are not community property, there are three, but only two of them really come into play in most situations. And so those two are property that the person owned before marriage. So anything that they own prior to the marriage is their separate property. And the second item of separate property is property that was acquired during the marriage by inheritance or by gift. So if you receive an inheritance from your parents or from your aunt or uncle, then that is your separate property. Now, about the only time that it's important to decide whether something is community or separate is death or divorce. If there's a divorce involved, then of course, the court will decide how to divide the community property. Generally, a spouse cannot be divested of separate property. And then the other situation is when someone dies, if they have a will, normally we don't need to determine if something is separate or community because the will says who gets what. But if the person never did a will or never did a trust during their lifetime, then we have to determine what is separate and what is community in order to know who has inherited those items. Mm-hmm. So again, the reason that you need a will is so that the property can go to who you want it to go to. Another thing is we need to have a person at charge. That person is the executor. If a person never does a will, never does a trust during their lifetime, then the court has to appoint somebody. The court may or may not appoint the person that you would have wanted. Mm-hmm. And a lot of problems arise in cases where, second marriage families, where there's blended families, there can be animosity between stepchildren. There could be animosity between stepmom and the kids. And so by doing a will or doing a trust as an alternative, you can decide who will be in charge of those things. So when people come to me to talk about estate planning, I tell them that there are 4 types of documents that are done most commonly. Those 4 documents are last will and testament, or in its place you can have a revocable living trust. The second document is a durable power of attorney, and I'll talk about these more in a moment. And then the third document is a medical power of attorney. And then the fourth most commonly done document is a directed to physicians, or what is sometimes called a living will, or a right to die document, and where you specify that you do not want to have you do not want to be kept alive on life support if you're brain dead or if if you're terminally ill. So with regards to those, I tell people of those 4, it's good. It would be good to have all 4. But if someone is trying to save money and wants to limit it, then I tell them, well, there's 2 that I put in the category of as being essential, and that is to do a will or trust and the durable power of attorney. So the durable power of attorney is important because if you should ever become incapacitated where you're not able to handle your affairs, your business, then you need to specify someone to take over and handle things for you. If you have done a power of attorney, then it will almost always eliminate any kind of a family fight over a guardianship. Because if there is no power of attorney, then the family often has to go to court and have a guardian appointed. Legal guardianships are very expensive. I call them the lawyer's retirement plan because they're lucrative for attorneys, but at the expense of the client. And so having a durable power of attorney can, in most situations, it will eliminate a family fight over who's going to be mom or dad's legal guardian. And then, of course, having a will is important for the reasons I mentioned. You can determine who gets your property in the percentages that you want, not to fall for this assumption that everything is going to go to the surviving spouse. That is sometimes true, but often not true. And then, of course, in a will, you also can determine who you want to be as executor. And I'll talk a little bit later about how wills are probated and so forth. Medical power of attorney is pretty self-explanatory. You just designate who will be in charge of making your treatment decisions. So a medical power of attorney is used in situations where there's still hope, and the doctors just need to have a person that will authorize treatment that will save your life. The right to die document simply specifies that if you either have a terminal illness or that you have a condition that is irreversible, such as brain dead, no brain activity, you're in a coma, then you can state what your wishes are. Obviously, most people state that it is their wish that the machinery be disconnected and that they not, be kept alive artificially. So those are the four most commonly done documents. Another question that arises often is, I've heard about living trust, and is living trust better than a will? So my answer is sometimes the living trust is best, and in other situations, just a regular will be all that you need. Living trusts do cost significantly more than wills, and so for that reason, once again, an attorney will make more money off of you by doing a living trust. But I try to, treat clients as if they're my own family, and I don't recommend something that they don't really need. And so generally, when I recommend a living trust over a will, is 3 or 4 situations, one of which is, first of all, if you have a dysfunctional family, and you think there's a good chance that there's going to be a family fight, a living trust has advantages over a will about eliminating that type, because if you have a will, it's pretty easy to contest the will. There's a forum already available with the court. With a living trust, it's a little more difficult to contest the trust. Second situation where I'd absolutely recommend living trust is for people who own real property outside of Texas, whether it be a second home, a lake lot, mineral interest, royalty interest in another state. I absolutely recommend that they do a living trust there. The reason is that normally the transfer of title to real estate after a person dies is done through probate. It's done through the probate court. If the person owns real property in more than one state, the will has to be probated in each state in which they own property, or they a lot of times it's mineral interest. They may own a royalty interest in South Dakota or West Virginia or Louisiana or Mississippi, and places where they are drilling. So by having a living trust, you not only do you not have to do probate in Texas, you also would not have to do probate in those other states. The title to the property can be transferred by the trustee through a trustee's deed, and no court is required to do anything. You don't have to go to court to get that transfer done. Whereas with a will, the will has to be admitted to probate in each state in which the person owns real property. So that means that I have had to probate wills in as many as 3 or 4 different states because the person owned condos or apartment buildings or whatever, rent houses in other states. So another situation I recommend a living trust is for people that have an intense need for privacy. Most of the time, a will is probated, and when the will is probated, the will itself becomes a public record. So, in other words, if my next-door neighbor died, and I'm just curious about, what he had and what was in his will, and wanted to read his will, I could go to the courthouse, and in some counties, you can actually get online and read somebody's will that has been submitted for probate. But of course, with a trust, it's a private document. It sits in your desk drawer, and nobody ever sees it unless you pull it out and allow them to read it. So, those situations, I do recommend a living trust. For most people in Texas, a will do just fine. The probate system in Texas is very economical and very streamlined, unlike the western states where probate is very expensive. In Texas, normally probate is not expensive. There are 2 situations where probate is very expensive, which is good for me and not good for the client. And that is, number 1, not having a will. If you don't have a will, for title to your real estate to be transferred, then your estate will have to go through probate. And probate, when there is no will, is expensive. It is inexpensive if you have a will and if the will is done properly. It's expensive, however, if you do not have a will. And a second situation where probate is expensive is family fights. When when there's a contest, either a contest over the will, or if the person dies without a will, then all of the person's heirs have to be notified, and then they find out what they're getting, and then there can be this is the occasion. There can be a fight over who's going to be appointed as the administrator, and then there can be a fight over whether something was community property versus separate property, because when there is no will, we do have to determine and allocate what is separate versus community, because the percentages and who gets what does change depending upon separate property or community property. In Texas, up until about maybe 10 or 12 years ago, the only way that your estate could avoid probate was by having a revocable living trust. And so when I started practicing law back in the 70s, 80s, 90s, I did many revocable living trusts. What has changed over the years is that some of the reasons for living trusts have now been kind of offset by some changes in Texas law that are very good. One is there is a way now for you to keep your assets that you have from becoming public record. By in some situations, you don't have to file an inventory with the court. And the second situation is that the number one reason that wills get probated in Texas is to transfer the title from real estate to the heir, to the person who's going to get it. That is by far the most common reason that wills get probated. And a second common reason is a bank account that did not have either a joint tenant or a transfer on death beneficiary. So what has taken place over the course of years is that for financial accounts, there are simple ways to transfer it to the next generation without probate, and that's through joint tenant with right of survivorship or having transfer on death, pay on death beneficiaries. And then for real estate, a law was passed a number of years ago, well, actually about 8 years ago, that allows a person to transfer the title to real estate through a transfer on death deed. So when people come to me and they tell me that all they have really is their house, they got some retirement accounts with North Texas Wealth Management, and then, a little money and so forth, then I tell them, well, I can do a living trust, or you can also avoid probate by doing a transfer on death deed for the house to leave it to the spouse, and then if the spouse predeceases it, leave it to the kids. And then the other assets, the financial assets, will pass outside of probate anyway because of the way you have them titled. And so it's possible for a person to not go through probate in that situation. Keeping in mind that probate in Texas is not the nightmare that you hear about in other states, but it can occasionally be. Now, I do not recommend the use of transfer on death deeds, once again, when people have dysfunctional family, because if they set it up where the house is going to pass to the kids through the transfer on death deed, the problem with that is that there is no person to charge. If the will is not probated, there is no executor, because you don't really become the executor until the court approves your appointment. If you go to the court, there's no executor. So because of that, if the property is left to the kids in equal shares, then if there's 4 kids, then all 4 of them, it has to be unanimous what they're going to do. Some of them may want to keep the house, not sell it because they want to rent it out. Others want to sell the house because they want the money. Well, the problem is that you can't sell a house. There are 4 owners of that house. All 4 of them have to agree. And so if there's a disagreement about selling a house versus renting, then you got a problem. Also, if there's disagreement about how much to sell it for, there's a problem. If there's disagreement about how much to rent it out for, what are you going to charge for rent, there's a problem. In that situation, they wind up having to go to court to get a legal representative appointed, and the court does what's called a partition. And the court normally what the court does is appoint a receiver to sell the property. So you're right back to, well, you should have just had an executor to handle it, because then the executor can make those determinations. So in those situations, I recommend that the people not do a transfer on death deed for the real estate. They need to either do a revocable living trust, because in that situation you have a trustee that's in charge, or do a will, because there you have an executor that's in charge. So that's kind of an overview. Otherwise, revocable living trusts are very good. I do both for people that want them, and what I find with people when trusts are quite a bit longer, have more pages than a will. And because of that, sometimes people don't really understand them, whereas they read a will so I have had people over the years to come back to me and say, can I just have like a regular will? I never have been able to really understand this trust business.
Yeah.
You know?
So with all these years of experience, what are some of the mistakes, pitfalls that people need to avoid?
Well, of course, one I already mentioned is I don't need a will because in Texas, everything goes to the spouse, which, as I said, sometimes it's true, but often it's not true. Another question I get is, well, can I just do my own will? And my answer is, well, yeah, if you do it right. But I would say most laymen do not know how to do a will correctly. They will leave something out. And I have people to bring me the will that they did, and it does not meet the criteria for being a will. The Texas Estates Code sets out the requirements for what has to be in a will, and doesn't meet that. I'm asked, well, what about if I just get a will form off the internet? I would say most of the time those wills either are no good or they're not Texas specific. Sometimes I will see a will form off of the internet that is pretty good. But I would say on average, and another problem I have with will forms is that you still have to fill in the blanks on those will forms. Sometimes people have brought me wills that they did and they didn't even fill in the blanks correctly, or they left blanks unfilled that absolutely need to be filled, So I would just say if you're going to do an internet form, it would be best to take it to an attorney and have them to review it. That sounds self-serving coming from an attorney, but they really need to have it checked out.
Yeah.
Another question I'm asked is, does Texas recognize handwritten wills? And Texas does. You can do a handwritten will. One essential requirement, however, is that every single word of it must be handwritten. If it is partially handwritten and partially typed or partially off of a computer, it is not a valid will. In Texas, a will does have to be witnessed by two witnesses that are of lawful age. Ironically, a handwritten will that is entirely handwritten does not require witnesses. It's great if you have it witnessed, but it doesn't have to be. So if somebody calls me up, and I've had this phone call, somebody literally calls me up at 10 o'clock at night and say, we're getting on a plane at 6 o'clock in the morning to go on vacation. We just thought we should have a will. I say, well, take out a piece of notebook paper, and I kind of tell some things to write, but write out a handwritten will, and then leave that in the house. Don't take it on the plane, because if it goes down on the plane.
Yeah. So,
and then when you get back, let me do you a better will. So those are things that sometimes people ask me. Again, ask me, is a trust better than a will? I've already discussed. Sometimes it is better. Sometimes a will and a transfer on death deed will accomplish your objective. Do we have audience questions from the audience, or
question? What would be a good vehicle for someone who decided not to leave their estate to any heirs, that they were going to leave it to a university or to a charitable organization?
Right. The question is, what if you don't want to leave your estate to any particular person, you just want to leave it to a charity or institution? That can be done. It has to be done in the will. You still need an executor because you have to have a person in charge to accomplish the transfer. But it is charitable gifts can be accomplished through a will.
And And what we found is some of those charitable organizations are willing to put together your legal documents if you're leaving a significant amount behind, right? Like,
Yes,
we'll facilitate whatever documents you need to leave us your fortunes, right?
absolutely. Yes, they will.
Well, that's great. Great information, and appreciate you being here, Mark, to answer that. Those are some of the common questions that we face. And I think the most important part is to realize that it's important to get your estate planning documents in order. I always say it's the last gift that you can leave your loved ones, and, not have that burden be your last memory. So thanks for tuning into this webinar for North Texas Wealth Management. Stay tuned for upcoming events. And of course, if you need any of the life planning, financial planning, investment management, we're here to help you. Visit our website, ntxwealth.com. Thanks.